Welcome to today's discussion. The topic of today's discussion is on vicarious liability in IPC. One of the fundamental principles of law is that a man is answerable under the law for his own acts. He cannot plead the unlawful order of his official superior in his defense. Let's see what vicarious liability is. The vicarious liability is a principle by which one person is held liable for another's wrong. Vicarious liability means the legal responsibility of one person for the wrongful acts of another person. The master or principal is responsible for the wrongful acts committed by his servant or agent, when the acts are done within the scope of employment. The maxim of qui facit per alium facit per se is a doctrine of civil law. Now let's have an understanding on the general rule relating to the vicarious liability in crimes. In the case of crime, only the person who actually commits the crime is normally responsible. In criminal law, the principal can be held responsible for the acts of his agents only when it is proved that he had instigated or otherwise abetted the acts of the person who actually committed the crime. In certain cases only, the acts or defaults of a servant or agent in the ordinary course of his employment may make the master or principal criminally liable. In such cases, a particular intent or state of mind should not be essence of the offense. There are certain exceptions to the general rule. Let us examine the exceptions to the general rule that in case of crime only the person who committed the crime is liable. The following are the exceptions. The first exception is, Section 154 of the Indian Penal Code. Section 154 enumerates the situation when owner or occupier of land on which an unlawful assembly is held. The code provides that, whenever any unlawful assembly or riot takes place, the owner or occupier of the land upon which such unlawful assembly is held, or such riot is committed, and any person having or claiming an interest in such land, shall be punishable with fine not exceeding 1,000 rupees, if he or his agent or manager, knowing that such offence is being or has been committed, or having reason to believe it is likely to be committed, do not give the earliest notice thereof in his or their power to the principal officer at the nearest police station, and do not, in the case of his or their having reason to believe that it was about to be committed, use all lawful means in his or their power to prevent it, and, in the event of its taking place, do not use all lawful means in his or their power to disperse or suppress the riot or unlawful assembly. That is, if unlawful assembly or riot takes place on the land of a person, and if he or his agent or manager fails to give the earliest notice of the unlawful assembly or riot to the principal officer at the nearest police station, the owner or occupier of such land is liable to be punished with fine not exceeding 1,000 rupees. The second exception is Section 155 of the Indian Penal Code. Section 155 provides for the liability of person for whose benefit riot is committed. The code provides that, whenever a riot is committed for the benefit or on behalf of any person who is the owner or occupier of any land respecting which such riot takes place or who claims any interest in such land, or in the subject of any dispute which gave rise to the riot, or who has accepted or derived any benefit therefrom, such person shall be punishable with fine, if he or his agent or manager, having reason to believe that such riot was likely to be committed or that the unlawful assembly by which such riot was committed was likely to be held, shall not respectively use all lawful means in his or their power to prevent such assembly or riot from taking place, and for suppressing and dispersing the same. That is, whenever a riot is committed for the benefit of the owner or occupier of any land who claims any interest in such land, if such person has reason to believe that such riot was likely to be committed, the owner or occupier is liable for fine if he has not taken all lawful means to prevent such riot. The third exception is Section 34 of the Indian Penal Code. Section 34 provides that acts done by several persons in furtherance of common intention. The code provides that, when a criminal act is done by several persons in furtherance of the common intention of all, each of such persons is liable for that act in the same manner as if it were done by him alone. That is, Section 34 deals with joint liability or vicarious liability on the basis of common intention. The fourth exception is Section 120A and 120B of the Indian Penal Code. Section 120A is on criminal conspiracy. The code provides that, when two or more persons agree to do, or cause to be done, 1. An illegal act, or 2. An act which is not illegal by illegal means, such an agreement is designated a criminal conspiracy. Provided that no agreement except an agreement to commit an offense shall amount to a criminal conspiracy unless some act besides the agreement is done by one or more parties to such agreement in pursuance thereof. Section 120b provides for the punishment of criminal conspiracy. 1. Whoever is a party to a criminal conspiracy to commit an offense punishable with death, imprisonment for life or rigorous imprisonment for a term of 2 years or upwards, shall, where no express provision is made in this code for the punishment of such a conspiracy, be punished in the same manner as if he had abetted such offense. 2. Whoever is a party to a criminal conspiracy other than a criminal conspiracy to commit an offense punishable as aforesaid shall be punished with imprisonment of either description for a term not exceeding 6 months, or with fine or with both. Quote, that is, Section 120A and 120B deal with joint liability of a member of a conspiracy to commit an offense. The fifth exception is Section 149 of the Indian Penal Code. Section 149 provides that every member of unlawful assembly guilty of offense committed in prosecution of common object. The code provides that, if an offense is committed by any member of an unlawful assembly in prosecution of the common object of that assembly, or such as the members of that assembly knew to be likely to be committed in prosecution of that object, every person who, at the time of the committing of that offense, is a member of the same assembly, is guilty of that offense. That is, Section 149 deals with joint liability or vicarious liability of members of an unlawful assembly when an offense is committed by a member in prosecution of the common object of the unlawful assembly. The sixth exception is Section 396 of the Indian Penal Code. Section 396 is on dacoity with murder. The code provides that, if any one of 5 or more persons, who are conjointly committing dacoity, commits murder in so committing dacoity, every one of those persons shall be punished with death, or imprisonment for life, or rigorous imprisonment for a term which may extend to 10 years, and shall also be liable to fine. That is, Section 396 deals with joint liability or vicarious liability of dacoits when a dacoit commits murder for committing dacoity. The seventh exception is Section 460 of the Indian Penal Code. Section 460 enumerates on all persons jointly concerned in lurking house trespass or house breaking by night punishable where death or grievous hurt caused by one of them. The code provides that, if at the time of the committing of lurking house trespass by night or house breaking by night, any person guilty of such offense shall voluntarily cause or attempt to cause death or grievous hurt to any person, every person jointly concerned in committing such lurking house trespass by night or house breaking by night, shall be punished with imprisonment for life, or with imprisonment of either description for a term which may extend to 10 years, and shall also be liable to fine. That is, Section 460 deals with joint liability of persons concerned in lurking, house trespass or house breaking by night when death or grievous hurt is caused by one of them. Now let's see how the doctrine of vicarious liability is applied under common law. In common law, the general rule is that the master is not vicariously liable for a crime committed by his servant as an agent. That is, in criminal cases, the principal is not answerable for the act of the servant. Let's see how the doctrine of vicarious liability is applied under a statute. In certain cases the master is to be made criminally liable under the doctrine of vicarious liability, and in such cases the legislature absolutely forbids the act and makes the principal liable without guilty mind, mens rea. It is to be noted that the master or principal cannot be held liable criminally for the acts of his servants, in the following cases. 1. Where servant has acted for his own or personal benefit. 2. Where servant has acted beyond the scope of his employment. Is the doctrine of vicarious liability is unknown to criminal law? If the doctrine of vicarious liability is unknown to criminal law, what are the exceptions to this principle? Let's see. Generally it is true that the doctrine of vicarious liability is unknown to criminal law. But, the master will be liable vicariously in the following exceptional cases. 1. Statutory liability. Where a statute provides for liability upon a principal or a master, even though he does not know of the forbidden act done by his servant, in such cases master is criminally liable. It is not necessary that he is aware of the said forbidden acts, and even where they are against the law and order. 2. Licensee's responsibility. It is well settled that the licensee is responsible for the acts of his employee, done within the scope of his authority. 3. Public nuisance. Under common law, public nuisance provides vicarious liability over master for acts done by his servant. 4. Negligence in duty. A person will be criminally liable if he entrusts some work to an unskillful person, which has to be done by himself under a duty and that has caused dangerous results. That's all for this video. Click on the bell icon to get notified when we upload new videos. Subscribe for more videos. Visit our website for MCQ examinations and notes on this topic. Happy learning! A video from Law Aspirants Hub.